Well, welcome everyone to our conversation today about the legislative process and tobacco control policies. So, as we get started, we always like to talk a little bit about the Public Health Law Center. We are an organization based in St. Paul, Minnesota, and we acknowledge that our presence is in the tribal and treaty homelands of the Dakota Oyate since time immemorial. These lands are home to the Sissetons, Wapitan, Mdewakanton, and Wakpetu Dakota peoples. This land acknowledgement was developed by the Native American Law and Sovereignty Institute at Mitchell Hamlin Law School of Law, and is being used here with permission. For more information on the indigenous peoples in these tribal lands, we encourage you to visit the URL on this slide. As professionals working with law and policy, we strive to center equity across our work in support of policy change that leads to a more just and equitable world. The roots of racism and other forms of systemic bias and oppression are deep, and we focus on social determinants of health to co-create healthier, more equitable communities with our partners and allies. So just as a disclaimer, and then also this is the type of work that we do. We do legal research, policy development, publications, trainings, but we don't do any direct representation or lobbying. So when you reach out to us, you don't have to expect that. But as a disclaimer at the outset, the three panelists here today are also state representatives in the Minnesota legislature. The Minnesota legislature is a part-time legislature, and so we are also staff attorneys with PHLC. But for this webinar, we are here in our capacity as staff attorneys for PHLC, and so we'll focus our attention on general legislative processes, as well as a vignette about the state of Ohio and nothing about Minnesota. And with that, I'll hand it over to my colleague, Jamie Long.
Thank you so much, Esther. Good to be with everyone today. So as a quick overview for the presentation we'll be making today, we are going to start with a legislative process 101 and hopefully give some tips even for those who are legislative process followers that you might not know about how a bill works through the process behind the scenes. And then we will give an overview on preemption and dig into a case study from Ohio, as Esther mentioned. And then finally, we'll have some tips for public engagement. So first, just a quick overview of the bill life cycle. A bill, of course, is introduced, and then we'll move through the committee process, followed by floor action in one chamber, and then floor action in the other chamber, a potential conference committee, and then action by the governor. So I'll be talking about each of these steps in the process. And to mention at the beginning, even though there are a lot of commonalities between different states and their structures and procedures, there are differences among the states. So it is important to know the rules of your individual state. One way that can be helped is by using resources like those put out by the National Conference of State Legislatures, where they track, for example, when your legislatures are in session, whether they're full or part-time. And then we'll even have resources about the rules in the different legislatures or some comparisons on policies. But the content we provided today should sound familiar no matter what state you're in. So the first step, of course, is the introduction of bills. And before a bill is introduced, there is a lot of work that goes into bill preparation. So that can include stakeholder engagement, trying to work on finding common ground or agreement before a bill is even introduced. And of course, a bill needs to be drafted before it can be introduced. And often this is done by professional staff at the legislatures or sometimes by state agencies who also have staff that are able to work on bills. Sometimes, though, a bill comes directly from an outside entity. So this could be anyone from a corporate lobbyist to a stakeholder or interest group that proposes a bill. And then for a bill to be introduced, it needs an author. And so an author can be chosen based on their interest in the bill or their interest in the subject area. Sometimes it's a strategic decision about who the author is. And then an author can have co-authors as well who are signed onto the bill. Some states limit the number of co-authors that can be signed on to a particular bill. And you may want to send a message with those co-authors. So, for example, getting bipartisan authors may send one message, or you may want regional representation or other kinds of diversity in terms of the authors. You may also want to seek a number of authors on the bill that are on the particular committee stops that you care about. And of course, in every state but Nebraska, you have a bicameral process. And so you are going to have coordination with the other chamber. And oftentimes you'll want to make sure that you are having a House and Senate author introduced on the same day or have some coordination for how they're introducing. You can see here there's one happy legislator putting their bill in what is colloquially known as the hopper, location that the bills are placed to be introduced. Some chambers limit the number of bills that each individual members can sponsor, and there also are sometimes limits on when bills can be introduced, particularly for part-time legislatures. So it's important to watch the deadlines as well. So this may sound like a straightforward question, but why are bills introduced? There may be many different reasons. So if you're tracking bill introductions and you see a bill introduced, it is often important to figure out what the intent is behind the bill author. One most common reason, of course, is to be able to move the bill through the legislative process, and that's pretty straightforward. They want to get it done this particular legislative session. But sometimes an author is just introducing a bill to show support for a particular cause. So they may have an important constituency that they are trying to help out with the bill introduction, or they may just be trying to start a conversation for action in a future legislative session and have no intent at all to try to move the bill that particular session. So once a bill is introduced, then the next stop is the committee hearing process. And this is where the bulk of the substantive work occurs. Members are often assigned to committees based on their interest or their expertise, and members are assigned by leadership typically. So some of the more plum committees, like the Budget Committee or the Tax Committee, may have legislators assigned to them based on their years of experience or their interest in those particular areas. And then the bills themselves are typically assigned referrals based on legislative leadership. And the most common reason to refer a bill is that it is within the committee's jurisdiction or subject area. There may be a number of committee stops that a bill has to make. For example, if a bill is broad in scope and has 2 or 3 different committees that have overlapping jurisdiction with the bill, then it will have to stop in each of those committees along its path. The bill referral process can sometimes be used strategically by leadership. So, for example, if leadership opposes a particular bill, they may decide that they want to refer it to a chair who also opposes the bill, knowing that it is unlikely to be coming out of that committee. Or if they support a bill, they may take the opposite approach. And let's say there are several stops along the way, and they know that one chair opposes it, but all the others support it. They may start with the committees that support it so that they build some momentum for the bill's passage over time. The rules for each committee can vary by state, and they can sometimes even vary by committee chair. So the committee chairs often have quite a lot of leeway to set the rules for their own committee. But generally, you are going to see committees allowing hearings on a bill that will take public testimony with some limits on the time for testimony or on the number of testifiers. The hearing itself on a bill, once a chair decides to schedule a hearing, is typically the public's best opportunity to be heard in the legislative process. The bill sponsor will be the main presenter and then may recruit members of the public to speak to it or to be a part of their presentation. And often members of the public can come testify as well, even without leave of the bill author. Once the hearing is completed, then there will be an amendment process if the chair decides to move to that stage. And committee members can offer amendments to the bill or even substitute amendments that would replace the entirety of the contents of the underlying bill. Those then receive votes by the full committee. And this process is often colloquially called the markup. And then committee action is the next step. And so you can, as a chair, decide often if you want to report a bill out of committee. So that effectively means that a chair can kill a bill if they choose to hold it in their committee and not refer it out. But if they do refer it out, they can refer to the next committee stop or to the full House or Senate for action. Sometimes in some states, the committees refer favorably or unfavorably. And so if they are referring a bill out unfavorably, that often is a signal that they still have some concern about the bill or that the bill still needs some work. If a chair decides not to refer a bill out, some bodies have procedures that the whole House or Senate can follow to override a chair and take up the bill directly before the full chamber. This is often called a discharge petition that would require, for example, a majority vote of the whole chamber to overrule a particular chair. Another option, if there is a chair who is reluctant to move on a particular bill, is to try to find a path around that chair. And that may be more or less easy depending on the chair or the circumstances of the state, but you may be able to find a committee path that bypasses the chair or even find a bill vehicle that, for example, could be a budget bill or a larger bill that would be hard for it not to succeed, that you could include a particular provision in. So once a bill is referred to another committee or to the floor for consideration, then a committee report is processed. And this is a formal document confirming that the committee has acted. And the report will often be processed during floor proceedings for a bill to move to its next committee stop. So for example, if you have two committee stops, you will have the committee report leave one committee, go to the floor for action, and then it will be sent to the second committee stop, and that committee will be ready to do their own bill hearing and markup. Once the bill has completed all of its committee stops, then it is ready for floor action. In some states, there is a rules committee that determines if a bill will be added to the calendar for the day, and the rules committee tends to be controlled by leadership. So that gives leadership a large amount of control about whether a bill is going to be taken up by the full chamber. Bills also must generally receive 3 readings before they can receive their final vote. And generally, the requirement is that those readings be on separate days. A reading is simply a reporting by the clerk and does not actually, in modern times, involve an actual reading of the bill's text. So the first reading happens when a bill is introduced and it gets its first reading on the floor and then its committee referral. The second reading happens when it is scheduled to be taken up by the whole body. And in some states, they use what's called a committee of the whole. So they will recess the entire chamber and go into a committee of the whole, which is a way for the full legislature to act in effect as a committee to consider amendments. So once it's given its second reading, then it'll be time for amendments. And chambers have different rules, including sometimes limits on the number of amendments that can be offered, whether they must be pre-filed so that the public can and other legislators can see them ahead of floor action, or whether they can be offered in real time as the bill is being considered. So once the full chamber or the committee of the whole have gone through the amendment process, then the bill will be given its third reading, which means it's ready for the final debate and vote. And then when you are on the final debate, the rules can vary a bit by state as well, but most states set some time limits on the total time or the number of times a member can speak, or limit the time for the debate on the bill as a whole. Most states also have the option of motions that can cut off debate. Sometimes this is called calling the previous question, which would force a vote on a bill. And then after debate, the vote will be called on the bill. And in most states, a roll call vote is required for a bill's final passage. So, as I mentioned, except for Nebraska, which is unicameral, a bill must pass both the House and the Senate in an identical form in order for it to be sent to the governor. So there are 3 basic options at this stage. One is that the other chamber can simply accept and pass the bill. And if they've done that, it has passed both chambers in the same form and it is on its way to the governor's desk. Another option is for them to ping pong the bill and so make amendments in the chamber and then send it back to the other chamber. Typically, this only goes one round where a chamber will send a bill over, say the House, the Senate will amend it and send it back to the House, and the House will decide that they are going to accept it with the Senate amendments, and oftentimes those are pre-agreed to, and the chamber knows what's likely to happen if they send the bill back. But there are some times when you could see bills bouncing back and forth with different amendments. But more typically, if the two chambers are not going to agree, then they are going to go to a conference committee. And this is a committee of both bodies where there are equal members of the House and the Senate assigned to work out the differences on the bill. And appointment to the conference committee is generally done by leadership. And so this gives them some control over the shape of the conference committee and who will be on it. Conference committees can be the most important stage of the legislative process, as they are often where the very final deals and decisions are made. And even though it's called a conference committee, it may or may not look like a committee that you might see in the House or Senate. Sometimes they do look very much like that, and they have public testimony and are doing amendments in kind of a committee setting, similar to what you might see in a normal committee. But sometimes they are less transparent and may do negotiations behind closed doors, or make an agreement that is not in a formal public hearing process. Once the committee has agreed to a conference report that the members generally have to sign or agree to, with a majority of each chamber agreeing to the conference report, and that comes back to the respective chambers for their action. And what gives the conference committees so much power is that generally they cannot amend the conference report. So it comes back to the chamber only for an up or down vote based on what the report was. So once the report has been voted on, or the bill has made it to the governor's desk, and the governor has a few options. They can sign the bill, and then it will become law directly. They can veto the bill, and if they veto the bill, then the legislature can override it. Typically, that requires a supermajority vote that varies by state, could be 2/3, could be 3/5. Or the governor can sometimes refuse to sign and then allow the bill to become law without their signature, which is sort of a soft protest. Or they can pocket veto a bill if the legislature has adjourned in some states by taking no action. Some states also give the governor the ability to do line item vetoes, where they can strike out specific words or strike out individual budget items or provisions. And we've seen some governors use that very creatively in other states. So that is the quick overview of the legislative process. And now we'll turn it over to my colleague, Mike Freiberg, to talk a little bit about preemption.
Thank you, Jamie. Just give me 1 second to share my screen here. Okay. So during this part of the presentation, I'm going to talk about one specific policy issue that has the potential to influence all of the policy work you might be working on at the local level, and that's preemption, which is a little bit of a dry topic. It's not something that tends to generate huge headlines, so we refer to it sometimes as a quiet threat to public health. And I'll talk specifically about what preemption is, what you can do to prevent it, and ways to inoculate legislation against preemption. So first, what is preemption? Now, the dictionary definition is fairly on point. It just says it's a doctrine in law according to which the legislation of a superior government, such as a state government, supersedes that of an inferior government, such as a municipal government, in conflicts of law. Now, in America, we have overlapping levels of government. There's federal, there's state, and there's local governments. Sometimes all three levels of government can pass a law on the same subject. And if those laws are in conflict with each other, we need a way to decide which of these different laws will control the other. Typically, we say that the lower level of authority has been preempted by the higher level of government. So federal laws trump state laws, and state laws trump local laws. Now, sometimes people make a distinction between ceiling preemption and floor preemption. Ceiling preemption is the typical form of preemption in which the federal or state government sets a regulatory ceiling and prohibits local governments from regulating above that level. So an example of ceiling preemption would be a state minimum wage law that's set at $15 an hour, but it prohibits local jurisdictions from setting local minimum wages above that level. Floor preemption, in contrast, is when the state or federal government sets a regulatory floor and permits local jurisdictions to regulate above it. Now, in the minimum wage example, floor preemption would be setting a statewide minimum wage of $15 per hour, but permitting local governments to set local minimum wages above that level. Now, when we use the term preemption at the Public Health Law Center and throughout this presentation, we'll be generally referring to ceiling preemption. At the Law Center, we typically think of floor preemption as simply a form of regulation and not really a form of preemption at all, or at least as almost always being a harmless form of preemption. Sometimes it's helpful to think visually about this. So we have a federal system in the United States in which there are multiple levels of government with overlapping authority. And sometimes there are federal, state, and local laws all addressing the same issue or area. Preemption is the idea that when these laws come into conflict, the law or regulation from the higher level of government will prevail over the regulation from the lower level of government. It's important to note, too, that preemption can be pretty broad in its applicability. It's not just statutes passed by Congress that preempt laws passed by state legislatures. It can also be federal regulations. So rules or regulations passed by the FDA or EPA, those, just as much as a law passed by Congress, can preempt state laws, local laws, and it can even preempt lawsuits based on state or local laws. And that's largely true at the state level as well, with state laws and regulations preempting local ordinances or zoning codes. So let's just give one simple example to make sure we're all on the same page. So a state has a statewide smoke-free law that prohibits smoking in most places of business, but explicitly permits it in multi-housing. So it explicitly permits smoking in multi-housing. So the question would be, can a city pass a smoke-free multi-unit housing ordinance? And the answer, unfortunately, is probably not. It would depend on a few things, but this would be a standard example of preemption in which a state law preempts a local ordinance. The city can't prohibit what the state explicitly permits, and since the state law explicitly allows smoking in multi-unit housing, there's a good argument that a city can't prohibit it in a local ordinance. Now, what's wrong with preemption? There are a few basic reasons that preemption is problematic. So first, local governments know the local conditions best, and local leaders are most responsive to local community members. Preemption replaces local control with a one-size-fits-all policy enacted by people who are further removed from the communities who are directly impacted by those laws. Second, it impacts policy innovation in at least two ways. When you preempt local governments from acting in a given space, you shut off a major engine of policy innovation by limiting the number of policy experiments happening around the nation. Second, preemption locks in policy. So local governments, which are relatively nimble compared to state governments, and certainly more so than the federal government, they aren't, if there is preemption, they aren't allowed to adapt for changing circumstances or to incorporate new information. And policy change instead has to evolve at a higher level of government, where policy development typically happens more slowly. And finally, perhaps the most insidious element of preemption, it stops movement building before it begins. One of the big motivations for grassroots campaign is to change policy. And one of the easiest ways to change policy is to work at the local level, to talk to your city council person or mayor, who may oftentimes just be your neighbor. And if you can't do that because of preemption, you take some wind out of the sails of grassroots campaigns. Now I'm going to talk a bit about what you can do to prevent preemption. So there's a few steps that I think would be helpful. First is to prepare your legislative champions. This may not be an issue that your average state legislator is thinking about. You know, if you're working on a smoke-free policy, they're just thinking, well, we want it to apply to indoor areas, we want it to apply to patios. They tend to think about the more substantive aspects of that legislation, and they may not be thinking about effects that a piece of state legislation might have on local governments. So making them aware that it's an issue that you're working on, that the opposition will most certainly try to bring it into effect through the legislation. by adding it potentially as an amendment at some point is very helpful. So just making your legislative champions aware, and if it's a deal breaker for you or for your coalition, letting your legislative champions know that. Like if there's going to be preemption included, it's better to have no policy at all because we want to be able to continue working on that. So you'll want to think about this in advance with your stakeholders about whether preemption rises to the level of being a deal breaker for you. You'll want to keep tabs on the opposition. You'll want to know who the lobbyists are for vape shops, for big tobacco, for retailers. There could be a variety of groups that may or may not be organized against the work you're doing. Most states have a registry of some sort of lobbyists, a registry of some sort of all the lobbyists and who their clients are, so you can check that out. And this opposition to your legislation and the support the opposition has for preemption is more than theoretical. So I just included a quote here from somebody from Philip Morris. It says they are dead serious about achieving preemption in all 50 states. You'll want to consult with attorneys throughout this process. This isn't just a way for us to gin up business, but it can be a complicated issue. It can be very subtle the way preemption could be incorporated into legislative language. And on that note, you'll want to be looking for certain keywords that can indicate that there may be preemption. So those includes obviously the word preemption. If it says like this ordinance preempts, or this state law preempts all local ordinances on the same subject, that's pretty clear. But sometimes it might be words like supersede, or it might say every local regulation shall be consistent with state law, or it might say this law creates a uniform state standard. That by implication means there can't be local standards that get stronger than that. It might say like this is the exclusive piece of legislation on the topic. It might say this is meant to occupy the field of regulation on this topic. So you'll just want to keep a lookout for words like that because they are often used to to include some sort of preemption. So how do you inoculate against preemption? The best way to do it is through clear language stating that that local regulation is permitted. So that's most often that's something that we call a savings clause. So it might say just nothing in this statute shall be construed to limit a local jurisdiction from regulating tobacco products, or it might say nothing shall be in the statute shall be construed to limit a local jurisdiction from regulating where smoking can occur. So just having clear language in there that specifies that local authority is protected in the legislation is a very helpful way to inoculate against preemption. And you'll want to make sure, as Jamie described the process. I remember some bills have to go through multiple committee stops. So every committee stop is a potential to amend a bill, and this language can get included in multiple places during the process. So, or it can get weakened during those phases. So you'll want to be on the lookout for amendments that change this language or that incorporate potentially preemptive language. That's pretty much what I wanted to say about preemption. So I'm going to send the presentation back to Esther, who's going to go into more detail on a specific example of legislation.
All right. Thank you so much, Mike. I know we're going to switch slides here for a second. So before I talk about our specific example, I do want to discuss how the public can be more engaged in lawmaking with legislators. So as we've heard, for a bill to become a law, there's a lot of moving pieces. But one necessary piece of the process is understanding how the public feels. The public is who legislators represent and work for. And without the support of the public, it would be hard for most legislators to move their bill forward. So the easiest way for the public to get involved is to begin following bills that are introduced into the state legislature. And most states actually have a website dedicated to their legislature and where people have the ability to track bills that are introduced. And you can search for keywords, you can set up an alert, and then you can begin following a bill on its journey through committees, amendments, and floor hearings. And the website should also provide information about how to submit public testimony, either in written or verbal form. So when you're, next slide, please. When you are looking to engage with the public, It's important to know if you're looking at whether to craft this bill before it's been introduced or influence the bill after its introduction. And having allies with you to engage lawmakers can let lawmakers know that your policy area may have a greater constituency than originally thought. And so coalition members, building a coalition, it can be really important. And those can include other neighbors, people in a similar situation that the bill is trying to address, or organizations and groups that can help people organize around a particular issue. Coalition building is also important to help build deeper relationships with legislators. As they say, everything is about who you know. And the more legislators that you get to know and get to know you and your issue, the more likely that person, that legislator, is able to become an advocate for your cause or even sponsor your bill. If you are interested in organizing for a new bill, it's best to start early. So as Jamie mentioned, you'll want to engage with your legislators before the legislative session starts. Every state has a different calendar, so talk to your local representatives to see when is the best time to engage, to get a bill drafted, and start building support for it. And so by getting involved early and with more people, you can be effective at shaping the bill, either in crafting it or offering amendments along the way. And organizations who advocate for policies often look for individuals to share their story about their issue. So public testimony is really important here and can be a way to directly engage with legislators on a particular bill. You can also set up individual meetings with your representative to further engage them on the issue, especially if it's an issue that might be contentious, like preemption. So next, we'll talk about lobbyists. Lobbyists are similar to lawyers in that they can sometimes have a bad reputation, but similar to lawyers as well, they can also be quite useful at the right time and place. So if you have an advocacy organization or are building a coalition, depending on what the issue is or who your potential opposition could be, you may want to consider hiring a lobbyist. In the simplest terms, a lobbyist is a paid professional who advocates for your cause with legislators. And this can definitely be useful, particularly if you run an organization or lead an organization and need to focus more of your time and energy on the business of the organization rather than spending all day and all night at the Capitol. And so while a lobbyist is not a necessity, but it really just depends on your setup and your goals. So some organizations and other local efforts can find a lobbyist an additional useful tool to support policymaking through the legislative process. But again, depending on your setup and makeup, it's not a necessity, but something that can be sometimes nice to have. So now that you understand a little more about how a bill becomes a law, we'll use a real-world example of how tobacco control preemption provision worked its way through the legislative process in Ohio to become law. It took multiple steps and essentially went through every stop in the legislative cycle. And so how it started is it was originally introduced as in 2021, commercial tobacco control opponents introduced an amendment to an otherwise uncontroversial tobacco tax policy bill. The proposed amendment would have prevented jurisdictions below the state level from implementing their own tobacco control laws, like flavor bans. And so in Ohio, actually, at this time, a lot of observers saw that this amendment that came in 2021 as a response to the flavor ban that the city of Columbus had instituted earlier that year. So the bill that was introduced, where this preemption amendment came onto, was known as HB 513. And it was originally introduced in the Ohio House and discussed only on how to collect debt on tobacco products. So basically, the whole purpose of the bill was it would allow a wholesaler or distributor to obtain a refund of an excise tax on cigarettes and other tobacco products and nicotine vapor products that were remitted on bad debts arising from the sale of those products from essentially defunct retailers. So that bill was uncontroversial. A lot of people supported it. It was meant to move pretty quickly through the Ohio legislature. But when that bill moved from the Ohio House to the Ohio Senate for consideration, the sponsors in the Senate introduced the preemption amendment to limit tobacco and nicotine control policy to only the state and federal level. And like the language that Mike was talking about, they used similar well, they were actually pretty direct in their language, but they did use kind of similar subtle language, essentially saying that the regulation of tobacco products and alternative nicotine products is a matter of general statewide concern. And so to them, that was the signal to say that only the state or the federal government should be implementing tobacco regulation. And so legislative supporters of the amendment, they just really felt that tobacco control policy is much better decided at those levels. They were also concerned that limiting tobacco sales could lead to, as they say, the slippery slope of limiting sales on junk food or other products that are seen as bad for the public. So once the amendment was introduced, on the next slide, we'll see there was discussion by the public and legislators on whether the amendment was necessary for the bill. Public advocates came to a December 13, 2022 Senate hearing to express their opposition as to why tobacco control regulation is needed at the local level, where cities and other jurisdictions can tailor regulation to their needs. So groups like Campaign for Tobacco-Free Kids, ACS CAN, American Lung Association of Ohio, and more, all offered their testimony in opposition to this amendment. And after their testimony, Senate committee members debated the merits of the amendment. The supporters of the amendment who were on the committee, again, offered that the amendment prevents the restraint of trade that they thought that they were seeing at the local level. And they wanted the amendment there in order to stop cities in Ohio from telling people what they could or could not buy. But opponents of the amendment, particularly those from the public health communities, focused on the city's ability to regulate an addictive product because they saw that it was leaving kids and other people vulnerable to tobacco industry tactics to become more addicted to tobacco products or nicotine products. In the House, during its floor debate on the bill, some representatives expressed opposition to this amendment because they saw that it would severely limit Ohio's ability to respond to tobacco companies and the youth uptake of nicotine products. And they also saw that it violated the home rule in Ohio's constitution, which allows for local jurisdictions to be able to implement policies that they see fit for themselves. And some legislators also noted that because of the tobacco industry's tactics, it was actually leaving Black and Brown communities, other marginalized communities at risk of tobacco industry tactics. So a similar debate ensued in the Ohio Senate, but at the end of the day, in both the House and the Senate, there were enough votes to pass HB 513 with the amendment. And so once HB 513 passed both the House and the Senate, the governor indicated that he would veto the bill because of its preemption language. He noted that the bill went too far in limiting the ability of cities to respond to their needs as it related to tobacco control. He also noted the health concerns related to tobacco and nicotine products and did not want Ohio to not have a response to tobacco industry efforts that were keeping young people addicted to products like e-cigarettes. And so after the veto of HB 513, one would think that that would be the end of the bill. It went through its whole process. It had committee hearings, it had floor hearings, but at the end of the day, the governor said no. But as we know, in the legislative process, nothing ever really dies. Usually, it'll come back again in some other form, and it's often in the next legislative session or successive iterations. So for Ohio, in the next legislative session, the proponents of the amendment and preemption added the amendment to a much larger and much more consequential bill for Ohio, which was the education budget bill. By adding the preemption amendment to a necessary bill to fund education, it limited the attention on the tobacco preemption provision. And so that happened in 2023 with HB 33. The Ohio Senate added the preemption amendment to this large appropriation bill, knowing that it was a must-pass bill. And the bill did pass both chambers, and public health advocates had to rely on the governor again for a line item veto, which is allowed in Ohio. And the governor did just that by stating again that youth are susceptible to e-cigarettes and other nicotine products. And as a matter of public health, local jurisdictions should be able to address their own needs and concerns as it relates to tobacco control. But the proponents of this amendment to preempt tobacco control at the local level would not back down. And so even after the governor submitted his line item veto and his reasons for the veto, they still undertook a process to override that veto. And so the veto override was successful after passing the House at the end of 2023, and then it passed the Senate in early 2024. And this basically showed how the proponents of this amendment had exhausted the complete legislative process to get their bill passed, despite going through two vetoes in two separate sessions. And these events in Ohio show how a bill can become a law through different methods and tactics, and how legislators who have the power in a legislative body can use every tool at their disposal to ensure that their policy passes, even if it is a policy that may be detrimental to public health. So, as we'll see next, though, even though public health advocates did not succeed in the endeavor at preventing the preemption bill from becoming a law, and even though we weren't successful in the legislative process, we do have three branches of government, and another branch of government did step in to give public health advocates their victory. And so later that year, in 2024, state courts in Ohio did rule that the preemption provision was unconstitutional and violated Ohio's home rule laws. And so as we move towards the end, we see here that legislating is a very long process. Most bills actually don't succeed upon their first introduction. It can take a few sessions, and sometimes those sessions turn into multiple years, sometimes decades, before a policy finally gets passed. But the legislators and the public do not give up easily on their issue. And so oftentimes you'll see an idea get refined over time from when it was first introduced. It'll look really different from when it finally becomes law and starts to become implemented. And the legislative process really is about being deliberative, taking time and taking ideas or discarding some ideas, finding ways to get the public to support you. And so similarly, from a public engagement perspective, advocating for bills is also an endeavor in building broader coalitions just to show how much support you actually have for your idea. And while the legislative process may seem daunting with all of these steps and all of these places where you can get involved, it's better to think of it as building one relationship at a time to move a policy solution from an idea to a bill and eventually for a law. And so we thank you so much for your time today, and we are happy to take some questions. We will also have a publication, I think Jamie noted in the chat, that will kind of go through this. So you'll have something tangible in your hands or online that you can look at that will go through the process of the legislative process, preemption, and what happened in Ohio as this preemption bill went through each of the final stages. And of course, our contact information is on the screen, and we're always happy to answer any questions or work with any jurisdictions who are wanting to engage in the legislative process themselves.
Thank you so much. What a great presentation. Always learn a lot from you three. Just addressing a question that's in the chat. Will you send the recording? Yes, the recording will be emailed out to all registrants, usually within 48 hours. So expect the link either tomorrow or the day after for the recording and any additional, and the resources like the publication that was posted in the chat. So to start off, we're going to go through some question and answers now. First question that came up was, some community members might feel like they don't have enough specialized knowledge about the legislative process and think it's not for them. How can we make the public feel less intimidated and more empowered to get involved and make a small difference?
Sorry, you think you would know now after 4 years. Okay. Yeah, I think it is daunting. It can feel like a legislature is this huge behemoth of a building, and it's hard to get in there, hard to get to know people. But you don't actually really need a lot of specialized knowledge about the legislative process. You just need to be able to contact your legislator, whether that's your state representative or your state senator, whoever is more amenable to taking a meeting with you or responding to your emails, start with that person. And similarly, if there's a local organization that you know of that already advocates on an issue that you care about, get involved with them because they also have developed relationships with policymakers and lawmakers. So then that way, as you're involved in that group, your voice then joins with other voices and can be better at making that difference that you want to see.
I'd also add with people who might be reluctant to get involved in the legislative process, you can find activities for them that match their comfort level. I mean, testifying in front of a legislative committee may not be for everyone, but they might be comfortable sending an email to their legislators. And you can encourage people to focus on what they know. Legislators are people, and people tend to be more motivated by stories rather than data. So just encourage people to share their stories with legislators.
Great. And a follow-up question with that we had was, are there any other options available if people cannot directly speak to legislators per their organization's policy or grant funding rules? Who else could maybe they talk to?
I think that's when you can look at your state's rules or the rules of your grant to figure out maybe you have to go through other organizations that may have that capability of talking directly to legislators, or see if your grant allows for educational engagement. So that may be a way where you, instead of looking at one specific party, maybe you talk to all legislators on a committee, regardless of their party affiliation. So you're more giving information rather than advocacy work. Those are some ways to kind of get around those rules or find other people who can kind of speak on your behalf.
I'd just add working in coalitions can also be a way to help do that. So if you have as Esther mentioned, finding other folks, but if you have a big group, everybody might be able to pitch in something different. So you may be able to provide some background knowledge or information that can go into materials that others can share with legislators as well.
Great, thanks. Next couple of questions are regarding tobacco lobbyists. One question we have is, how do tobacco lobbyists promote or obstruct legislation? And then the other part is there a way to find out who the tobacco lobbyists are in various states?
Yeah, I can just mention, maybe take it quickly. So, one thing tobacco lobbyists can do is meet with legislators. Some lobbyists are former legislators themselves, so they might have relationships with legislators that they served with. And their activities aren't always super public. I'm not actually sure I've seen a lobbyist identify themselves as a lobbyist for a huge tobacco company and then testify publicly. I mean, people like that tend not to be very sympathetic testifiers, so that rather they might have somebody who is more sympathetic, like a small business owner, do the public testimony while they would meet with their legislators and committee chairs behind the scenes. In terms of where you can find them, I don't know. I don't know how every state does it. I mean, in Minnesota, lobbyists have to register with the state campaign finance board. So on their website, you can find out who lobbyists are and who they represent. And I assume many states have similar resources to that.
Okay. We have another question to kind of clarify where the lines are for advocacy, lobbying, and education. Someone can maybe clarify the difference again, advocacy, lobbying, and education.
Yeah, I think, those are always kind of, in some cases, terms of art. Some states have done a good job of really clarifying what each definition is. But in states that haven't, I think one way to think about it is if you're doing advocacy work, you're usually advocating for a very specific issue to a very specific group of people who can take action on your behalf. Similarly, with lobbying, oftentimes lobbying, you're getting paid to do that work. So you will likely need to register with that state to show that you are a lobbyist. You can have multiple clients as a lobbyist. So what you'll often see in different states is if you see someone registered as a lobbyist, and if they need to list their clients, they'll have clients across the board from environmental organizations to big businesses, banks, et cetera. And so I think the notification that you are getting paid for your advocacy work is sort of what differentiates lobbying from general advocacy. And then finally, education is really meant to just provide the information with no form of action that you want the policymakers or lawmakers to take. You're really just describing an issue. So in the case of tobacco control, for those of you who may be on grants or programs that you can't advocate or lobby, but you can provide information on what the latest studies say about tobacco and nicotine addiction or tobacco industry tactics for marketing, or how the trends have changed with certain groups and how they uptake tobacco products. And so that can be education because you don't necessarily have an ask at the end of it.
Awesome. Thanks for that great explanation, Esther. The next question we have is related to the recent Supreme Court ruling, Chevron deference, and is it impacting the legislative process we talked about today? This person says, especially with the looming Project 2025 and its limitations on minority public health disparities.
Yeah, I think the Chevron ruling, if you follow PHLC, you'll see that we have uploaded some blog posts. I think we also have a video explainer about Chevron deference, and we'll soon have another webinar about its effect at the federal regulatory level. I think for the states right now, or any legislative process, whether Congress or the states, what is really going to happen is I think Congress is going to have to start writing more specific laws, which is a little bit harder in this environment, considering that we know that Congress hasn't passed a lot of legislation lately. But I think for states, state court systems all have their own agency deference, and it varies across the spectrum of how closely it had aligned to the previous Chevron doctrine. And so now, if those are changing at state court levels, state legislatures may also want to decide if they want to take on more specific legislation about what agency deference looks like in their state, or if it's a state that has already done away with agency deference, state legislators there are going to have to write more specific laws to be very clear about what the role of the agency is as it pertains to a particular issue or regulatory issue. So that's kind of where it is right now. But as a lot of attorneys have been saying, is watch this space, watch the court cases that come down in the federal judiciary to see how Loper Bright and its other cases similar to it that were released that same week are going to affect the regulatory process at the federal level.
Great. Looking in the chat, I see another question. Specifying says, in New Jersey, if there is a state law, such as a smoke-free parks law, a local municipality can take the smoke-free park law and make it stricter. Is this a common practice across different states? Is it something that can be addressed?
Yeah, that's a pretty common practice. That just means there's no preemption in New Jersey when it comes to smoke-free laws. So there are some states, unfortunately, that preempt smoke-free laws, but there are many that don't. Some in their laws explicitly say that local units of government can pass stronger regulations of smoking. So that could include smoke. If the state law only prohibits smoking combustible tobacco products in parks, but the local unit of government wants to prohibit the use of e-cigarettes in parks as well, then if there's no preemption, then they can adopt that as well. It sounds like that's the case in New Jersey. So hopefully you can keep it that way.
Awesome. Thanks for that explanation, Mike. So it looks like we're wrapping up with questions here for the day. I'll wait just a minute or so just to see if anyone types one in. Otherwise, we can give you back a couple extra minutes. We want to thank you so much for joining us for the session. Like I said, the webinar will be recorded. We will include a PDF of the slides, and the publication will be linked on our webinar landing page, which will be emailed out, as well as on our local authority page on the Public Health Law Center's website. Also, regarding if you're looking for CLE credit, the application is still in process. We anticipate it being approved. It just might take a couple additional days. please expect an email from us later this week or early next week. If you don't hear from us, feel free to ping me, Stephanie Lackey. My email is the one on the Zoom registration emails, and I will double check. Also, we do have this webinar available for direct CLE credit. So if someone watches the recording and would like CLE credit, they can apply for that as well. All right, without further, I do see, never mind. That was just a thank you in the question answer. So without further ado, we will end today's presentation. Again, thanks so much for joining us, and you will see an email from us soon. Have a great rest of your day.